Hello and welcome to Intellectual Property. This is Class 1, and I'm going to provide an introduction to both the class and to the concept of intellectual property. I'm your professor, Brian L. Fry. I've been a professor here at the College of Law for 8 years now, but this will be my first time teaching a law class entirely online from the get-go. So bear with me. I'm learning in the process, as are all of you, and I hope you find these materials interesting, useful, and edifying. So the class is pretty straightforward in a lot of respects. We're going to be doing a broad survey of the entire gamut, more or less, of intellectual property in this class. And so as of necessity, we're going to be going more broad than deep in a lot of respects. Right? We're going to be talking about a lot of different things, and the idea is really to get across some core concepts in intellectual property so that you're familiar with what's at stake and that you can identify the problems that might be presented to you in practice and have some sense of how to deal with them, but we won't necessarily get into the real weeds of many of these doctrines. And if you are interested in studying particular areas of intellectual property more deeply, I encourage you to consider taking my classes on copyright or trademark law, or maybe even my seminar on intellectual property theory, in which you'll be able to engage in intellectual property research on a subject of your own choosing. Okay, so in this class, we are going to be meeting remotely entirely. So I'm going to be recording a video for each class explaining the materials that you've read and providing kind of a gloss on the concepts that I want to discuss. This one might be a little bit longer than some of the other videos. I'm going to try to keep them to more about 15 minutes or so, but because this is an intro, it might take a couple of extra minutes. And then we're going to have time during our regularly scheduled class sessions to discuss both the materials that you've read, as well as questions that I will pose to you via Canvas for you to reflect on and think about in the context of our class discussion, right? So you'll want to come prepared to our regularly scheduled class discussions, both to talk about the materials that you've read and that I've talked about in the video, but also prepared to answer or at least reflect on the questions that I'll circulate to you prior to class. And of course, the casebook for the class is Lauren and Miller, Intellectual Property Law Cases and Materials. It's available either electronically via the Semaphore Press website or on Amazon. You can purchase a hard copy. And once you've obtained your copy of the casebook, please be sure to answer the 2-question casebook survey that is on Canvas for you as well. In addition, during the course of the semester, I will also provide written assignments occasionally for you to perform on your own via Canvas, right? So there'll be a range of different learning modalities, as it were, addressed in the class. Okay, so as for office hours and so on, I will often be available after our regularly scheduled discussion meetings to discuss with you any questions, concerns, or other issues that might come up. So, feel free to ask if you want me to stick around, and I'll make an offer at the end of the discussions when I'm available to stick around as well. If you want to schedule meetings, feel free to email me, and I'll work you into my calendar wherever I have some open space. I'm usually pretty flexible about that. If you're interested in additional intellectual property content, you can easily find me on Twitter and Facebook. And a lot of my feed there consists of intellectual property related issues. If you're a real masochist, you can find my scholarship on SSRN. Feel free to check it out. A lot of it is intellectual property related and might be of interest. And if you're really interested in intellectual property and legal scholarship more generally, you might also enjoy my podcast that I do with a number of other co-hosts called Ipsa Dixit, in which I interview, or we interview mostly law professors, but not exclusively, about their scholarship. And a significant portion of the material in the podcast consists of intellectual property related content. Okay. As for grading, your grade will be based on the final exam for the class, and grades will be curved according to the College of Law reg. I don't agree with it, but I'm stuck with it, so nothing I can do about it, and I apologize for that. For those of you who haven't had my classes before, my exams are a little different, perhaps, than you might have had in some of your other classes. Rather than an in-class or timed issue spotter exam, I assign take-home research memoranda for you to complete on your own time. The exam will consist of 3 questions that will be based on real-world problems, right? So often I'll use a complaint that's been recently filed or a dispute that's broken out in the media that relates to an intellectual property related question, and I'll provide that to you as one of the exam questions. Each memorandum will have a 1,000 word limit exclusive of footnotes, so the footnotes won't count toward the maximum word count of each memo. And the exam is entirely open universe. You can use any materials you want in preparing your research memo, and you can talk to anyone you want to about the questions as well, including each other. Right? The exam will ask you to position yourself as, essentially a junior associate or a law clerk, and so you're entitled to do anything that a junior associate or law clerk would do under the circumstances. And of course, when you're in practice or when you're clerking, you'll be talking to other people. So I want to mimic that same experience. You should feel free to talk to other people about the questions. In fact, I encourage you to talk to your classmates about the questions in the exam. The only thing that I ask is that everyone prepare their own exam. Now, it doesn't mean you can't share ideas and use the same arguments, but I do ask you to write your own exam. And that's because part of the project here is not only to be teaching intellectual property, but also giving you an opportunity to practice legal writing and legal drafting and legal research while you're learning intellectual property. And so writing the exam up yourself is going to be a part of that learning process. You'll have about 3 weeks to write your exam. I'll prepare it as soon as I can, and as soon as I have the exam ready, I'll make it available to you. I like to give students as much time as I possibly can to write their exams, because to my mind, the better you do on your exam, the more you learn, and the better a writing sample you'll have down the line, especially if you want to apply to a job that has an intellectual property component. So hopefully you'll find it interesting. And the idea is for the exam in the class to be part of the learning process of the class, not merely an evaluation of how well you've been able to pack material into your head. Okay, well, let's talk a little bit about intellectual property then. What is intellectual property anyway? When we talk about intellectual property, what do we mean? What does it refer to? And why do we use the term in the first place? So I'll be candid, right? I actually think intellectual property is basically a meaningless term. Right? We use it as a grab bag catch-all term for a broad range of different kinds of exclusive or semi-exclusive rights that are protected either by federal or state governments via statutory or common law processes. So there's a very wide range of different things that we put into this basket, doing and attempting to accomplish all manner of different things. And there's really no particular reason to think about them collectively, right? We put them into one basket, but in a lot of ways, there's not a really good reason to put them into one basket. In fact, many of them have very, very little to do with each other, except for one thing, right? The one thing that arguably does tie together all of the things that we call intellectual property is that in one way or another, they reflect exclusive rights in intangible goods of one kind or another. In other words, this sort of binding quality of the category of exclusive rights that we talk about when we talk about intellectual property is that they don't attach to tangible things, or rather, to the extent that they reflect tangible things, the intellectual property rights in question protect the intangible elements of something that's embodied in a tangible thing, right? So that's really what we're talking about, is a particular kind or a particular class, or maybe a set of particular classes of exclusive rights in intangible goods. Okay, so there's lots of different kinds of intellectual property, which I've sort of put into different categories for you here. So some forms of intellectual property go to rights in information, right? And so the tort of misappropriation protects valuable information simply by virtue of it being valuable. That's the first kind of intellectual property we're going to talk about in our next class. By contrast, trade secrets protect confidential information. So they protect valuable information, but only insofar as that information is confidential, and only insofar as the owner of that information makes an effort to keep it confidential. Okay, other kinds of intellectual property don't protect information qua information, but they protect particular kinds of ideas for particular purposes, right? So you're probably familiar with patents, right? You've heard of patents before. Normally when people talk about patents, what they're talking about is a particular kind of patent known as a utility patent, right? So a utility patent protects an exclusive right in new inventions and discoveries, right? So the core requirement for protection by a patent is that an invention or discovery has to be new. It has to be novel in order for it to be protectable. And in fact, patent law can't protect constitutionally an invention or discovery unless it's novel. Why is that? Right? Because the purpose of patent law is to encourage people to come up with inventions and share them with the world. And if people are coming up with things that aren't new, then everyone already knows them. There's no reason to protect that, right? So patents only go to new inventions and discoveries. Likewise, other kinds of patents like design patents and plant patents also require novelty, but they go to different kinds of subject matter, right? So plant design patents go to new ornamental designs that are protected by patent law, right? So in other words, it's the look of an article of manufacture, a look of a product, not what the product does, that's protected by a design patent, right? Utility patents protect the functionality of a product. The design patents protect the way the product looks, right? So we're distinguishing between the functional aspects and the ornamental element aspects of a product, right? And plant patents protect new varieties of plants, right? So if you're engaging in horticulture and you've come up with, say, a new rose, right, or a new kind of fruit, a new variety of fruit, you can get a plant patent if you can show that that variety that you've come up with is in fact new. Okay, other kinds of intellectual property rights go to particular kinds of expressions, right? So copyrights are probably the most familiar. Copyright protects works of authorship, and specifically, it protects original works of authorship. So the core requirement for copyright protection is originality, in the same way that the core requirement for a utility patent or any other kind of patent is novelty, right? Why is that? Because copyright is intended to encourage people to produce works of authorship. And if the work of authorship already exists, and it's not original, well, there's no reason to extend copyright protection to it. That work of authorship is already present. So we only extend copyright protection to original works of authorship. There are another couple kinds of intellectual property rights that are included within the chapter that holds the Copyright Act, although they're a little strange and it's not entirely clear whether they really belong there. We're not going to spend a whole lot of time talking about them, but just so you know that they exist, right? There's an entire body of intellectual property law that goes to protecting vessel hull designs. In other words, the shape of a boat hull is independently statutorily protected by intellectual property rights. And the story behind that is kind of long and convoluted, but essentially the Supreme Court in a case called Bonito Boats said that intellectual property, or rather various other kinds of intellectual property rights couldn't protect vessel hulls. And so vessel hull manufacturers went to Congress and said, hey, we need a sui generis form of intellectual property rights to protect our original vessel hull designs, and Congress, in its infinite wisdom, obliged them with their own category of intellectual property rights. Similarly, mask work rights protect new semiconductor designs, right? So new computer chip designs also have a separate form of intellectual property protection. Okay, and then a final form of intellectual property rights is what I like to refer to as commercial goodwill, right? In other words, sort of the goodwill or the inherent value of a business enterprise of one kind or another. One familiar kind there would be trademark law. So under both federal and state law, trademarks or distinctive marks and what we call trade dress or the appearance of a product can be protected as a trademark, and you can have exclusive rights in using that mark in commerce, right? So there's certain limitations on what trademark can and can't protect, and of course, we'll talk about that later in the class, or the contexts and purposes for which trademark protection can be asserted. And that's, basically anything that is distinctive can be a mark. So in the same way that when it comes to ideas like patents, we expect novelty. When it comes to expressions like copyright, we expect originality. When it comes to trademarks, we expect distinctiveness. That's the fundamental quality of a trademark, is distinctiveness. A mark has to be distinctive in order to be protected by trademark, because distinctiveness reflects the ability of the mark to communicate information to consumers about the source of the goods or products or services in question. Okay, and then the final form of intellectual property right that goes to this commercial goodwill category that I was talking about is rights of publicity, right? Essentially, a right of publicity is a state law right, so it differs from state to state, and the scope and duration of right of publicity protection depends on the state in which a particular celebrity typically is a citizen, and it protects the exclusive right of that celebrity, of that famous person, to use their name and likeness for commercial purposes, right? So it's an exclusive right over somebody's personality and effectively the ability to sort of use their personality to sell or promote goods and services. And it's sort of like, you might think of it as sort of like an exclusive right to endorse something. Okay, so lots of different kinds of intellectual property. We're talking about a lot of them, but not all of them in the course of the class. But I just wanted to kind of situate you in the context of what we're going to be discussing. So I thought I'd give an example of something that might be helpful in terms of thinking about how intellectual property works and what it looks like. Here's a little video clip I'd like you to watch. And while you watch it, I'd like you to look and think about aspects of the clip and the clip itself that might be protected by intellectual property rights. In other words, what kinds of intellectual property rights do you see going on in this clip?
Prepared to give a complete demonstration. Okay, Garth. Just sit there. He's gonna put that thing on your melon, okay? Just a trim. Don't buzz me, all right? Exactly how does a suck work? Well, as you can see, it's as it does. It certainly does suck.
Okay. So in our discussion, we're going to talk about this clip and try to identify the different kinds of intellectual property that are present in the clip. I'd like you to spend some time thinking about that and write down whatever kinds of intellectual property you see in this clip and describe what the nature of that intellectual property is. And I'll put up something for you to comment on that prior to class. I'll put an assignment up as when I put up the video. Okay, now I want you to think about this clip as you look at this next clip. So assume that this device pre-existed the suck cut pictured in the last class. I want you to ask yourself, are there any aspects of intellectual property that you see in this clip? And to the extent that you understand how intellectual property works already, would you be worried if you were the inventor or manufacturer of the suck cut about any potential infringement based on this device? Here you go.
Hi, I'm Brian Collins, thanking you for purchasing the Flowbee. Proper suction is the key to getting great-looking haircuts with no cleanup. An up and down bouncing motion works best.
Just bounce it into here.
So
So again, you bounce it the same way.
Gary,
what other kinds of haircuts can you do with the Flowbee?
Just
Just
bounce
bounce it all over your head?
One
One that I especially like, and I'll probably go back to using it again because it's so effective and efficient, is cutting it all one length. Cutting it all one length, Brian, allows me to cut my hair in maybe about 2 to 3 minutes.
A lot of kids like trendier haircuts. They like it very short here
and then long,
right.
Or any variation on that. Can they do that with this? Yeah, same principle. The only difference, I pretty much have that kind of trendy haircut.
Going back to the 60s, what about flat tops or buzz cuts?
Flat tops are easy to do.
Gary, it seems like with the Flowbee, you can do any kind of a cut imaginable. And of course, with kids these days, we're talking about any kind of a cut imaginable.
Absolutely. That's one of the great things about the Flowbee is that you can experiment. You can create.
God, kids are willing to do that these days. Not me.
Right. Yeah, absolutely.
When I cut my hair, I just put the Flowbee in my head and kind of bounce it up and down. Make sure that you bounce it up and down. I personally like to use a wedge cut. I never look as if I need a haircut. And I never look as if I just got one. When I want to let my hair grow longer, I just let it grow longer where I want it to grow longer. And then come in shorter where I want it to be short. I just like to experiment with the Flowbee. You can get very creative.
Absolutely.
As you can see, Flowbee's just taking off a little bit of hair, and it's trimming her bangs just like she wants it. And it's a bouncy motion that I go up and down, and her hair is perfect, and it feathers the bangs so nice. It's as simple.
So I will confess, my father threatened me with a Flowbee haircut as a kid, and I ran away screaming. Lately, however, my pandemic cut has certain Flowbee characteristics, so apologize for that. Anyway, what's the basis for intellectual property protection? I want to do a little bit of theorizing here for you and give you a little bit of a background as to what we're doing and why we're doing it when we talk about intellectual property, right? So the most fundamental basis for at least some of what we call intellectual property rights is actually constitutional. It's the intellectual property clause of the Constitution, Article 1, Section 8, Clause 8, which says the Congress shall have power to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So essentially, the intellectual property right says to Congress, you can create particular kinds of intellectual property rights. Specifically, you can create copyrights and patents if you want to, but you don't have to. And the reason that the Constitution will allow you to create copyrights and patents is because doing so may promote the production of works of authorship and inventions and discoveries. In other words, this is an option that the Constitution gives to Congress, but not an obligation, right? Congress can create these rights, but it doesn't have to. And that's consistent with a lot of the rest of Section 8 of Article 1, which gives Congress powers, but doesn't obligate Congress to exercise those powers. Of course, Congress did, in fact, exercise the power to create intellectual property almost immediately. In fact, shortly after the Constitution was ratified in 1789, 1790, the Congress passed the original both Patent Act and Copyright Act, right? So we've had the potential for people to claim and own patents and copyrights from really early on in the American Republic. And in fact, there were certain kinds of patents and copyright protections available under the Articles of Confederation as well, but that's a little esoteric at this point. In any case, how does that actually work? The intellectual property clause indicates its intention to provide both copyright and patent protection kind of in a parallel fashion, right? So when we look at the text of the clause, it says the progress of science and useful arts by securing to limited times authors and inventors the exclusive right to their respective writings and discoveries. So the progress of science in kind of 18th century parlance meant knowledge, right? So the progress of science enables Congress, or the promoting the progress of science is the purpose for Congress to give authors the exclusive rights to their writings, right? By contrast, useful arts in the 18th century was seen as mechanical or technical developments and skills. So promoting the progress of useful arts justifies giving inventors exclusive rights to their discoveries. Right, so we can think about the language of the clause in parallel. In addition, Congress has relied on its Commerce Clause authority to create trademark protection, specifically because for much of the early American Republic, in fact, until the late 19th century, Congress didn't really try to create any kinds of federal trademark protection at all. And when it initially did, Congress tried to create trademark protection under the Intellectual Property Clause. And the Supreme Court said, no, the Intellectual Property Clause goes only to patent and copyright. It doesn't give Congress authority to create trademarks. So after kind of floundering for a while, Congress came back to the Supreme Court with a new trademark act, eventually the Lanham Act. There were some intervening federal trademark acts as well. And in that, it relied on its Commerce Clause authority, which gave Congress the power to regulate commerce with foreign nations among the several states and with the Indian tribes. And as I'm sure you've learned in your constitutional law class, at least at this point, Congress's power under the Commerce Clause is just about plenary. It can do almost anything it wants to, and trademarks pretty easily fit within the scope of, especially what was understood as the post-New Deal scope of Congress's ability to create federal trademark protection. So no problems there. And we currently have both a federal set of trademark protections as well as every state has its own trademark law as well, although in many respects, state trademark law has become largely redundant, although not entirely. In this class, we're going to be looking only at federal trademark protection, but in my trademark seminar, we'll at least touch, or trademark class, we'll at least touch on state trademark protection as well. And note that I distinguish under trademark law, we have both federal and state trademark law. When it comes to patent and copyright, those are purely federal, right? So there's no such thing as there's no such thing at all as state patent law. There's a very limited subset of arguably copyright-related common law rights that are state-based, but they're very limited and really only go to certain kinds of sound recordings at this point. So broadly speaking, copyright protection is almost entirely federal as well, and we're only going to be talking about federal copyright protection in this class. Okay, so why do we have intellectual property then? What's the justification for creating intellectual property rights in the first place, right? Well, the sort of prevailing theory, and the theory based on the Intellectual Property Clause, is that the purpose or justification of intellectual property rights is what we call consequentialist or utilitarian. In other words, we create intellectual property rights because we think that the consequences of doing so are going to be good consequences. Specifically, we're going to promote the progress of science and the useful arts, right? Or we're going to promote the creation of original works of authorship and the generation of novel ideas, novel discoveries and inventions by virtue of creating copyright and patent protection. Right? Well, why would that happen? I mean, why would we think that creating copyrights and patents might produce good outcomes, might encourage people to produce works of authorship and inventions and discoveries when they otherwise wouldn't? Well, it's sort of a prediction made in the abstract by neoclassical economics or by kind of standard economic theory, right? And specifically, a particular kind of theory we refer to as a public good theory, right? So essentially, a public good is any kind of good that's both non-rival and non-excludable. What does that mean? Well, non-rival means that consumption of the good doesn't deplete the quantity of the good. So most goods that people consume, right, when they get consumed, there's less of the good left for available for other people. Right? So for example, if I have an apple and I eat the apple's gone, right? Only one person can eat the apple, not multiple people. So an apple is a rival good, right? If I eat the apple, you don't get the apple. I can cut the apple in half, we each get half, but then neither one of us got a whole apple, right? So there's only one apple available, and we have to decide, how to divide that apple up. This is a problem we call scarcity, right? And that's what, in a lot of respects, kind of traditional economics is made to deal with scarcity. And we use the price mechanism and so on to determine sort of who's going to have the best use for the apple in question. And we think about distributional consequences, blah, blah, blah. But when it comes to public goods that are non-rival, we don't have to think about those problems, right? Because ideas and expressions, right, the kinds of intangible goods protected by patents and copyrights, they aren't scarce, right? They aren't depleted by consumption. An infinite number of people can read a book, right? Especially when it's online, or use an idea, and there's just as much of the expression or the idea left available afterward, right? In other words, using the intangible good doesn't decrease the quantity of the good. If anything, it actually spreads it more broadly, and in some respects makes it more valuable, right? So we don't have to deal with the scarcity problem, which is great, right? But it creates its own problems, especially if the goods in question are non-excludable. In other words, if the person who owns the good can't stop people from consuming it, right? Well, then we have an issue, and that issue is what's known as free riding, right? The idea is that if consumers can consume the good without depleting the quantity of the good, right? So there's no scarcity, and no one can stop them from consuming it, well, consumers aren't going to pay, right? Because why would you pay for something that you can consume for free? Well, that's great insofar as the goods already exist. The problem is that marginal producers, in other words, producers who are making the decision whether they are or aren't going to invest in the production of new inventions or discoveries or new works of expression, aren't going to do so if they don't think they can recover their investment. Right? Because the problem is that even though consuming works of expression, consuming works of authorship, consuming inventions and discoveries doesn't deplete the quantity, you still have to create them in the first place, and that requires an investment of resources, right? So the problem here is that we're worried that authors and inventors won't invest, or at least won't invest as much as we want them to, in producing new work of authorship and new inventions unless they can prevent people consuming them without paying, right? In other words, what does intellectual property do? Specifically, what are patent and copyright supposed to do? They're supposed to solve what we call market and government failures in these kinds of public goods. In other words, a market failure is when a free market in the good in question wouldn't produce the optimal quantity of the good. In other words, it wouldn't fully satisfy consumer demand. Well, we're worried about the market on its own satisfying consumer demand for works of authorship and inventions, right? Because authors and inventors, in the absence of patent and copyright protection, at least in theory, won't have an incentive to invest in the production of works of authorship and inventions. We're going to get too few, right? So the idea is that providing exclusive rights, propertizing them, as it were, encourages authors and inventors to make that investment and ultimately benefit the public, right? Moreover, in many respects, when we're worried about market failures, we just rely on the government, right? We say to the government, well, government, we're expecting an underproduction of this kind of good. We want the government to subsidize it, right? So at least in theory, the government could solve market failures in works of authorship and inventions directly rather than indirectly through intellectual property protection, simply by subsidizing the production. It could pay authors and inventors directly to produce those goods, and then it wouldn't have to create intellectual property protection in the first place. And in many respects, it does so, right? The government spends a lot of money investing in research, scientific research, to encourage people to invent things, right? To come up with new ideas. And it spends a lot of money subsidizing various kinds of authors through grants and so on as well. The problem is we're worried about information costs in the government, right? The government doesn't always know what to subsidize, and sometimes it makes the wrong choices. And so our hope is that by making this subsidy indirectly through the lens of intellectual property, we can make it more efficient and better approximate the production of the kinds of inventions and works of authorship that will actually benefit the public and that the public actually wants to consume. So the basis then for the consequentialist or utilitarian theory is essentially that intellectual property is a means to an end, right? The reason the government creates intellectual property protection, the reason it's justified for the government to create intellectual property protection is because it ultimately benefits the public more, right? We refer to this as the intellectual property quid pro quo, right? Something for something, quid pro quo. Essentially what that means is the government says to authors and inventors, we, on behalf of the public, are going to give you exclusive rights because in exchange for that, we will get inventions and discoveries that are ultimately worth more to the public than the exclusive rights the public has given you. In other words, the public pays authors and inventors in the form of exclusive rights, and it receives from inventors in the form of works of authorship, and inventors and authors in the form of works of authorship and inventions. And at least in theory, what the public receives is worth more than what it costs to get those things in the first place. So the abstract theory behind the consequentialist or utilitarian approach to intellectual property protection or conceptualization of intellectual property protection is the bargain, and that ideally, at the end of the day, the public benefits from the bargain more than it costs the public. Now, we'll talk about in this class whether or not there's reason to believe that's actually true, right? It's certainly the case that intellectual property rights at least sometimes incentivize authors and inventors to produce works of authorship and inventions. Do they always, right? Does the public actually get more than it pays for, right? Does it always need to give those rights in order to provide an incentive, right? In other words, are those incentives always salient to authors and inventors, or sometimes are they maybe not so salient? Is sometimes the public paying when it doesn't need to, right? These are tough questions to answer. There's reasons to think that maybe sometimes we don't need to give intellectual property rights, or maybe simply even that maybe sometimes we give more intellectual property rights than we really need to. But at least the dominant prevailing theory of intellectual property rights is this consequentialist or utilitarian approach that says, look, the justification is that we get more than we give when we create intellectual property rights. And that's the premise of Article 1, Section 8, Clause 8, right? In order to promote the progress of science and the useful arts, you can give away these rights. But what does that mean, right? In order to get good stuff for the public, right, Congress can create these intellectual property rights. Now, I say this advisedly with a bit of cynicism because we say that this is the justification for intellectual property rights. But in practice, why do most people actually think that intellectual property rights are justified? I submit that it really has very little to do with this consequentialist theory I just discussed. In fact, I suspect many of you may never have heard of the consequentialist theory I just discussed, or ever conceptualize intellectual property protection in those terms. Why do most people actually believe that intellectual property rights are justified? I would suggest that most people have a much more kind of moral view of the justification, what we might refer to as non-consequentialist or deontological positions on the justification for intellectual property rights, right? One version would be kind of a Lockean natural rights theory, which says that authors and inventors have a right to own and control the fruits or products of their labor. In other words, I made it, I get to own it, I get to control it. That's my moral right. Right? There's also a kind of more continental or European idea of moral rights that says that, in a sense, like works of authorship and to a lesser degree inventions are sort of expressions of the autonomy or personality of the person who created them, and therefore you're entitled to ownership of those things insofar as you need ownership in order to promote and advance your sense of personhood. However you want to characterize it, I would suggest that sort of most people's kind of moral intuitions around the justification for the protection of intellectual property rights are really based in these kind of moral one or more of these moral rights theories rather than in a consequentialist position. And I think you can see that play out in how intellectual property rights are actually constructed and how they're applied by courts, not to mention in sort of the broader cultural discourse or social discourse around them. So, during the course of the class, keep your eyes peeled for these theories in the way that courts and others talk about intellectual property rights and why protection is justified or unjustified in particular circumstances. We'll come back to them over and over again over the course of the class, thinking about the logic of what the courts are doing when they discuss the development and scope of intellectual property protection. Okay, so here you can see just a kind of a map of different kinds of intellectual property rights and just a sort of basic amount of information of just how important intellectual property rights are, for better or for worse, in the US economy. Right? So increasingly, in pretty much any practice area that you're in, you're going to encounter intellectual property rights in one form or another, right? Any business you work for is going to have, for example, trade secrets relating to confidential information the business uses in the course of its operations, right? It's going to have trademarks relating to the branding of the business and its products. It's going to have copyrights potentially relating to any kinds of works of authorship that the business produces in the context of both doing business and producing products. And it's likely to have patents in many cases as well, especially if it's producing consumer goods. Right? It might have patents in how the goods are made, what the goods consist of, how the goods are packaged, et cetera, et cetera. Right? So you may not think of certain kinds of businesses as being IP heavy, but in many cases, they actually really are a lot more so than you might otherwise think. And hopefully this class will provide you with a framework for thinking about and identifying intellectual property related problems in your own practice, right? Now, of course, there's an entire side of intellectual property law sort of devoted to skeptics, right? And I'll admit some sympathy to the people who are skeptical of intellectual property protection. They point out that for a very, very long time, intellectual property protection was quite limited, right? But as is so often the case when it comes to property rights, they tend to expand rather than shrink. And over time, and this cartoon is specifically pointing to copyright law, but the same is true of patent law. The scope of the law, the scope of what it protects, and the duration of protection has gradually increased over time. We'll talk about that in the scope of this class, right? Maybe we'll ask ourselves, is that a good thing or a bad thing? Right? Did we really need to expand the scope of protection? And to the extent we did, is that producing better results, or is it just forcing the public to pay more to the people who happen to claim those property rights? And specifically in the context of copyright, right? A lot of people argue that copyright has simply become a tool of corporate capitalism, right? That ultimately companies want to own everything and control everything, and they don't want people to be able to get anything without paying for it, even if at the end of the day, that might be more efficient and more productive. So keep that in mind during the course of the class. Hope you enjoyed this video, and I look forward to talking to you in person soon.